Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Let's take a look at what we have here. All right, the first item up. Whoa, and I seem to be missing those. Do you have the minutes in your package, gentlemen? I'm missing the minutes in my package.
Well, they weren't in the ones I printed online. I thought they were
Okay.
going to be here.
So I'm going to suggest that we pass on that item.
Sure.
And Sheila, if you make a note that we have to come back to that at a future meeting. All right, next up, item number 4, resignations from the Board of Finance, and this is for information only, but Kevin Hopkins, Democrat, 76 Bennett Street, for a term of 11/15 to 11/21, resigned this past week. His letter of resignation, dated June 26th, is in your packet, and he asked that that be considered effective immediately. Item number 5. First Selectman reappointments. This is also for information only, and this is for the Cable Advisory Council for Area 2, and Stuart Stresler, unaffiliated, from 56 Lamplighter Lane, for a term of 7/17 to 7/19, and his reappointment date was July 10, 2017. For those of you that look, there is a packet that identifies the Cable 2 Council. Is Stuart here? No, okay. Just to give a little bit of background, not to spend a lot of time on it since he's not here, but there still appears to be a conflict between our Fair TV ordinance and the Cable Advisory Commission in terms of what they want one representative. Our ordinance says that there'll be a number of representatives on that, and I think the two groups have been discussing for a couple of years now, I believe, if they can get those reconciled. And I think the Fair TV Commission may at some point come back and look at revisiting this with our ordinance. I don't know which way that's going to go. I'm kind of hoping that the groups will work together. And at the moment, by appointing one person, that meets the CAC requirement, as I understand it, and it's acceptable to the Fair TV Commission, at least on a temporary basis, why they're discussing that. From this point, I've kind of left it to those two groups to sort it out, since they're both kind of independent from the town.
So the CAC is the Cable Advisory Council?
Yes. And that it's for Area 2, and that represents about 6 towns.
Okay.
So I don't know where Stratford fits within that, but I believe they're included in that also. I think it's Bridgeport, Stratford, Fairfield, Milford, Orange, and Woodbridge.
My effort was to connect the CAC to the people at home, or I guess the
Okay.
government.
Got it. So it's separate. It's not part of government. It's really an organization that was set up to help disperse funds that are added into cable TV bills, and then it's used to fund local TV efforts.
Okay.
So that's all. And certainly, if we needed more background, we can certainly invite Fair TV folks here to give us an update if we thought that appropriate at some point.
Yeah. That might be a good idea at some point, just to give us a briefing. And that aside, Stuart has a fabulous resume for this kind of a commission. He's got a great background in media, and I'm sure he'll do a great job.
Yep. And I should point out, he's on the Fair TV Commission, and that's where that
Yeah.
background really comes in handy.
Absolutely, yeah.
All right. Sheila, if you could just make a note of that as an action item to perhaps get Fair TV in here in August or September and give us a brief update. All right. Next up, item 6 is an appointment to consider and act upon the following appointment to the Board of Finance. Elizabeth Zezima, Democrat, from 160 Fairfield Woods Road, for a term of 11/15 to 11/21, and this is to fill a vacancy for Kevin Hopkins, who resigned. I have a motion to accept.
So moved.
A second? I will second that. Any discussion? And I believe Ms. Zesma is here if we had questions.
Yeah.
Not yet, not yet.
Well, a couple things on this. One, I appreciate your willingness to serve, but that being said, in the past, we've had an agreement between the parties that the boards would support the nominees which come from the parties. And I have a question. Did the Democratic Town Committee vote on this appointment?
They did not.
Okay. All right.
Though it was recommended by the leadership of the DTC, and Chris, I realize you're not a member of the DTC, but the DTC has a kind of different focus of practice on that. And certainly, she has the strong recommendation from the membership of the DTC.
Okay. So in past practice, I feel like we had an agreement which was in place. I absolutely feel like that agreement was violated last December by the Democratic Party when we, as a board, voted unanimously to support Ed Bateson to fill the vacancy of Lori McCardle. The Democratic Party went out to work hard to overturn what we had for many, many years as a party agreement. That being said, I don't believe Ms. Zesma is a very good fit for the Board of Finance for one particular reason. One, its unfortunately divisive nature. I've seen for years and years of posting on social media, and some of us just ran campaigns talking about how we wanted to tone down the rhetoric we have here in town. So my concern is that we're putting someone divisive on the Board of Finance. So for that reason, I'll be voting no.
Thank you.
Well,
Mr. Connolly?
sir, thank you. Well, I certainly appreciate the civics lesson. Thank you. But I disagree with your comments entirely. Ms. Zesma has been a good contributor to our town for many years. She's got a good, diverse, and a professional background. She has the best interests of our town at heart in all the decisions that she's made in the boards and commissions that she has served on. And I feel confident that she'll do a good and an outstanding job as a member of the Board of Finance, and I plan to support her.
I would add, I've had a chance to work with Liz for a number of years now, and I think she's got a great background, both from her professional work as well as her work on the RTM and the Finance Committee. I disagree with your comments about December, frankly, and I think that the only votes that I know that were not in support of a nominated candidate for an elected office are frankly when the Republicans didn't vote for my appointment to the Board of Selectmen in 2011 and potentially this one. So I think that that's certainly an interesting turn of events, and that wasn't, when I look at that, I certainly supported Mr. Baldwin when he went for a board, and I supported Mr. Walsh when he went for, and those were the two people who would refuse to, Baldwin, who was chairman of the RTC at the time, who lobbied strongly against my appointment, and Mr. Walsh, who refused to vote for it for 6 straight weeks. And that was pretty well publicized at that point. I think that taking into account people's positions during campaigns, frankly, would lead to a lot of things. I can go through a number of people that said things on social media and other points during campaigns that when the campaign's over, we still have to work together. And I know Ms. Zesma, I have a high respect for her character, and I know she'll do her best to both fit in and work as part of the Board of Finance and any other board that she's been on. She has done that in the past.
And if I may add to that, please, I had the pleasure of serving on the Board of Finance for 15 years and being the chairman of that board for 5 of those years. And we had a great team for all those 15 years. And I had the pleasure to speak with Liz personally twice in the last week. And we talked about the history of the Board of Finance, what they do, how they do it, why people look to the Board of Finance for long-term leadership and guidance and decision-making for our town. And we met eye to eye on those topics, and I'm confident that we both came away from the conversation with a clear understanding of the duties, responsibilities, and I'm confident that she will perform those duties and responsibilities to her best abilities and in the best interests of our town.
All right. With that, any comments from the public? If you'd be good enough to come to the podium and introduce yourself.
Helen Devans on Jennings Road. I am a member of the DTC, and I strongly support Elizabeth Zezima for the Board of Finance. I have the dubious distinction of having served on the Board of Finance briefly and lost the election. Life goes on, and now I get to watch on Fair TV. So, I have watched Liz Zezima on Fair TV frequently. Her decorum, her articulate, cogent analysis of all situations and positions is exemplary, and I strongly support her nomination. Thank you.
Thank you. Any other comments from the public? If you would.
Hi, my name is Heather Dean. I'm at 919 Stilson Road. I also serve on the RTM in District 3 now. This is my 6th term on the RTM, and I've had the pleasure of serving with Liz Zezima for, I believe, I want to say 3 terms, 4 terms? 2. 2, it does. It's been wonderful. And I can tell you that I was going to encourage her to run for the Board of Finance, and then I found out that she was going to be running for the Board of Finance because it is a perfect fit. The type of work that she does right now is with international trade. She understands finance on a national level, on an international level, and how it impacts us on a local level. I could not see anyone who is more fit and capable for this job. And as far as being anything other than professional, let's not confuse commentary of being succinct and on point as being disruptive, because they're totally different things. And I have found Liz's comments to always be succinct and on point and very specific. So I support this nomination completely. Thank you.
Thank you. Any other comments from the public? Seeing none, back to the board. Are we ready to vote? All right, all in favor?
Aye.
All opposed?
Aye.
All right,
No, I'm opposed.
thank you.
Congratulations.
Liz, congratulations. All right, next up, item 7. For the Board of Selectmen approval, to hear, consider, and approve the following appointment as recommended by the Board of Library Trustees. The Board of Library Trustees, Christina McGowan, Democrat, 155 Warwick Avenue, for a term of 7/17 to 7/23, and this is to fill a vacancy for a member whose term has recently expired. May I have a motion to accept?
So moved.
A second. I'll second.
I'll second.
Any comments from the board?
Is Christina here?
She is.
No?
Right here.
Thank you for your willingness to serve.
Mr. Cowley?
Yes, sir, thank you. Christina is a great fit for this role. I had a chance to speak with you and discuss your background and your dedication to libraries your entire life. And you've got a great resume and a great energy to add to our board, and we look forward to having you be part of it. Thank you for volunteering.
All right. I'm absolutely wowed by your background. I went through that resume, and
Yeah.
we didn't get a chance to talk because I was on vacation last week, but I am wowed by the resume, and it wasn't worth the phone call because you've done. You're just superb background. So again, thank you very much for your willingness to serve. Any comments from the public? Seeing none, back to the board. We're ready to vote? All in favor?
Aye.
Aye. Again, congratulations, and thank you for serving. All right, next up, item 8, from the Director of Parks and Recreation, and this does require RTM approval. To hear, consider, and act upon the following resolution as recommended by the Director of Parks and Recreation. Resolved that Michael C. Tetro, First Selectman of the Town of Fairfield, be, and hereby is, authorized to apply for the 2017-2019 Fairfield Youth Services State Grant in the amount of $25,188 per year for 2 years, and to execute such documents to facilitate such application. Further resolved that the town match funds for said grant in the amount of $25,188 as already contained in the fiscal year 2017-18 budget and personal services and shall be included in the fiscal year 2018-2019 budget in personal services. Further resolved that upon receipt of said grant funds may be expended as set forth in the grant documents. May I have a motion to accept?
So moved.
A second.
I'll second.
Mr. Calabrese, can you fill us in on what's going on?
I can. So this grant of $25,000 per year for the next 2 is basically our youth services grant made available to us by the State Department of Education. We've applied for this grant and we've received these funds for the last 25 years. So we have a pretty good track record with them. Yes, I know the state is in disrepair right now, but I'm encouraged that we will be getting this grant again. Some of the things that this includes, we take $16,000 for administrative and direct services. That covers clerical support and some staffing down at the Beanery building. We have $4,900 that goes to Fairfield Community Services, which is our subcontractor for youth and family counseling. And then the other $4,200 or so goes to program supplies, mainly to support our town youth council, which has 65 high school students from Ludlow, Ward, and Prep. Snacks, bus transportation for some of their events that they do, awards for our foul shooting with the W during Thanksgiving week, for our food drive, glow necklaces for the tree lighting, some supplies for our holiday breakfast and our Easter egg hunt, and then rounds it off with some sound equipment stuff down at the Beanery and April Vacation Camp, which provides camp for 100 kids during the April vacation week. The match, I'm sure there'd be questions about the match, but it's in the budget. The match goes directly to our only recreation coordinator that's left on staff right now to pay part of her salary. So that's where that money is going.
Okay. I have a couple questions. Just to clarify and set parameters for this, obviously the state budget's a big issue.
Yep.
So from the top, the state budget has not been passed. If the state budget is not passed for another year, what happens? Does any of this money come through? Is this basically waiting on the current state budget to have this passed?
It is. Obviously, we were encouraged to still apply for it. I don't want to say we were told that we're going to get it. I mean, we can get anything less than $25,000. This is up to $25,000. I mean, obviously, we've had $25,000 last year. They could come back and say, we're going to give you 10, or we're not going to give you anything. And all the things that I just listed are the things that would be affected.
Yeah. There are two different types. My first question is if there's no state budget, all right? Because we could be in a situation where for the next year, there's no state budget.
Correct.
If the state budget isn't passed, we get zero. Is that my
Correct.
understanding?
That's correct.
All right. So in that case, what are we doing here?
The things that I just listed would end up either being cut, or we would try to absorb in our 124 account, which is basically our self-sustaining program account, and try to cover it with program fees, which $25,000 is a significant amount. So yeah, I think we would cut back on some of these things if we didn't have this approved.
Okay, so we have a number of things we will be talking about in the rather near future in terms of state money not coming through.
Yep.
So we'll put this on the table for that.
Okay.
All right. Gentlemen, I'll open it up to you.
Please, go ahead.
I was going to ask, so the plan is to spend $50,000 total between 25 match and 25 grant.
Correct.
Would, since there is going to be, there's no state budget now, and when's the first time you're going to plan on tapping into this money? Would you spend the money up to 25 and then run out before the Easter egg roll, or are you planning on spreading it out throughout the year with lesser amounts, like lesser glow sticks? Cut the glow stick budget in half.
I'd have to talk to my staff and see where we can cut back. I wouldn't want to say, yes, we're going to cut back on this when I haven't discussed it with my staff. But there would be certain events, Easter egg, you might be right. It might be less prizes for the Easter eggs or less glow necklaces. Maybe we go without the glow necklaces.
Right.
Things of that nature. The administrative staff, the $16,000 for the administrative staff, I would try to transfer that right into 124 and pay for it with programming. I mean, that's an essential position that we have at our front desk right now.
Yeah. And I think this, to some degree, that's the conversation that I just referenced that Mr. Calabrese and I will be having, as well as every department head. Because as long as if the state is not going to pass a budget, forget what they will pass eventually. If they're not going to pass a budget, we have to go back and look at, like, we're not getting $5 million. So we're going to have to take appropriate steps to make adjustments. And some of those adjustments will be significant. There is no way around that. To cut the budget we have now by $5 million is not easy under any manner, way, shape, or form, and the inactivity at the state is going to force us to take action. So in the very near future, we will be sitting down, and I've already asked the department heads both to reach out to other towns to see what they do and what we can learn from them to make sure that we have best practices. But there is no easy way around that. If we don't have the money, we cannot spend it. So that's going to be an ongoing challenge.
Question.
Go ahead.
Thanks for being here. Can you talk a little bit about the revolving account, 124, I believe you mentioned, and do we still get an annual kind of view on that in September, October timeframe? Can you update us a little bit on the account, at least generally now, and give us some leadway into a more detailed conversation on the account? Because you may or may not have wiggle room within that account to offset either a shortage from the state or a shortage within our town budget, correct?
Correct. So our 124 account is an account that basically funds our programs, our youth soccer, youth basketball, things of that nature, summer camps. Everything that's in those programs are self-sustaining. So basically they either break even or they bring in revenue. So in October, which you were referencing, is when anything over $200,000 in that account goes back to the town, the general fund. We keep the 200,000 because that keeps us rolling for the next
Right.
year, so we can do our programs.
Right.
But anything over the 200 goes back to the town. So right now, I looked at it about a week ago, and there was 800,000 in there. But we're in the middle of summer camp season right now. All those field trips, staff, shirts, you name it, all that stuff gets paid. So that will dwindle down as we get closer to September.
Sure. Now, last year, how much did we return to the town, or did we?
So this fiscal year that just closed, we were asked to bring in an additional 200,000 on
Okay.
top of the 80 that we already had guaranteed.
So you guarantee the 80 like last fall,
Correct.
and then you had
And then
another
we were-
280, or another
Another
200.
200 on top of that.
And that
And-
money is, that 280 is already out of the numbers that you just mentioned?
Correct.
Okay.
Yeah, we guaranteed that we would turn that back in.
Okay. Without holding you to it, any visibility on where you think you could be on October 1st? Are you ahead of the curve, behind the curve? Are you right on the
We
line?
are ahead of the curve
Okay,
right now.
okay, thanks. And will we get an update October?
Yeah, typically, we provide that to the Board of Finance for their quarterly reviews, so yeah,
Good.
absolutely.
Thanks.
You're welcome.
Since this is a 2-year grant, if we didn't participate this year, what are our obligations once we say yes to this? Are we obligated to fund our portion of it? And if we didn't, what would happen?
We are. We'd be obligated to fund our portion, the match. If we didn't, then we would lose the funding, provided there is funding.
Got it.
So,
Okay.
just to clarify the question, if the state says yes, but for some reason we were to say no to the match, then the state piece is at risk, is what you just
We
said?
would lose that, yes.
Okay, thanks.
All right, thank you.
You're welcome.
Any further questions from the board?
Yeah, listen, I don't envy the spot you're in. I work in a town and I have to deal with the managers all the time, and, I guess it's the residents at home. The state has not put anybody in a good position right now. We are starting week number 2 of the fiscal year, and we still have an uncharted path. And here's one example of things, almost every parent of younger kids in town takes advantage of our town rec program, whether it's going to the Christmas tree lighting or, like myself, having the kids enrolled in the summer camp opportunity, because one, it's great value, but two, it accommodates a working family's schedule. And here we have the uncertainty coming from the state of Connecticut, which is definitely having a trickle-down effect. And you hear it today from you, so Anthony, I sympathize with where you're at. I encourage the state of Connecticut and Hartford and our delegation to come to a budget agreement sooner rather than later, so that we can have the certainty to move us forward.
Yeah, no, you're absolutely correct. I mean, you've got the double whammy in that your town doesn't have a budget as well as dealing with the state. But just looking at the state, some of the things, this is about parks and recreation. And I don't mean to minimize that at all. But I just had a meeting this morning with our social services director, and she informed me that heating assistance is not in the governor's executive order. So we're going to have people expecting heating supplements that we have given them year after year because of their income position that will not get that. I read an article yesterday that talked about rent subsidies. So those people in the most needs, in such a need that their income lets them qualify for subsidies from the state for rent, will not be getting those subsidies. Starting in September, people can start losing their homes. So this is, as much as we don't see it day to day necessarily, in a very few short weeks, this is going to impact people in Fairfield, but very definitely people throughout our state that are not in good shape. The issue of the state going on without a budget is going to hit crisis proportions very quickly. And I think we all are in agreement on that. I think it's, you're going to hear me saying at every public meeting I'm at, because I think that maybe perhaps all of our residents don't understand the import and the impact and the significance of the state not having a budget and what it will mean at towns like this. So, any further comments from the board? Any comments from the public? Back to the board. We're ready to vote?
Yes.
All in favor?
Aye.
Aye. Thank you, Mr.
Thank you. I've
Calabrese.
left you the application, and my office can pick it up anytime.
All right, thank you.
Thank you.
All right, next up, item 9, to hear an update from the special election, on the special election from the town attorney. Mr. Lesser, just thought since the election is on one hand over, I did ask the town attorney to come up and give us an update as to where we are and what happens from here.
Can I ask before we start on this?
Go ahead.
So the agenda says an update on the special election. Special election's over, election will happen. Is this an update on the legal case? And should this be an executive session because it is a pending legal case right now in the appellate court?
At the moment, this is just taking us through what the special election has done, and potentially, it's not over because an appeal is still pending. But the question was to understand in public, not legal strategy by any stretch, but in public, what has taken place from this point. Because the town is not, well, I'll let our town attorney take us through this so that we are clear, because I think there are a number of questions out there as to what has happened so far and what takes place from here.
Yeah, very briefly. I'm only going to be talking about matters that are public record, not litigation strategy, anything like that. And I was asked by the first selectman just to give an update of what's happened. And quite frankly, in order to do that, I had to go onto the Judicial Department website and print out, and what I did was basically created a timeline of all the motions and such that have been filed. It's all information that's public information, and I'm just going to kind of recap what it is and just tell you where we are. What you do with the information is up to you. So just very briefly, in answer to Mr. Tetro's question, from what I can determine from the Judicial Department website, what we have pending right now are two actions. There is an appeal to the appellate court of the Superior Court judge, Judge Bellis's judgment ordering the election to take place. That's one action that's currently pending. The second action that's pending is, and that was filed on behalf of 4 of the defendants in this case. There were 5 original defendants, the 3 selectmen in their capacity as selectmen, the Board of Selectmen, and the town of Fairfield. That appeal that I just mentioned was filed by 4 of the 5 defendants. The one that didn't file it was First Selectman Mike Tetro. There was also pending an action that was filed, again, by the same 4 defendants, and Attorney Baldwin has been representing those 4 defendants. There is a petition for certification which was filed with the Supreme Court, asking the Supreme Court essentially to review the appellate court's action in finding that there was no automatic stay in place. And so that's also pending. So the question is then, how did we get to that stage? And I'm just going to go through what I've determined are the facts, or what's been filed based on my review of the appropriate websites. So I'm going to start with the March 10th rendering by Judge Bellis of her decision, which she rendered in open court, And she rendered judgment for the plaintiffs in the case, and she read her opinion from the bench. 5 days later, Attorney Baldwin requested Judge Bellis to forward her findings to the Supreme Court for purposes of an expedited appeal. That request was denied. On March 16th, Judge Bellis issued a memorandum of decision in which she articulated her reasons for finding in favor of the plaintiffs in ordering that the special election for the selectman seat held by Mr. Bateson take place. And she also rendered an order setting dates for the election. On March 30th, about 2 weeks later, Attorney Baldwin filed a motion for an expedited appeal to the Supreme Court. That motion was denied by the Supreme Court without prejudice, and without prejudice to renewing it based on what the trial court did with any question of the stay of execution. On April 5th, Attorney Baldwin filed the actual appeal with the appellate court of Judge Bellis's decision. And again, that appeal was filed on behalf of the Town of Fairfield, the Board of Selectmen, and the two selectmen, Bateson and Timniak. And just, you should note that all the subsequent pleadings filed by Attorney Baldwin were filed on behalf of those four defendants. On April 17th, the plaintiffs filed a motion to dismiss the appeal in the appellate court as being untimely filed. That motion was denied by the court, so the appeal remained pending. On April 20th, First Selectman Tetro sent a letter to Attorney Baldwin directing him to cease his representation of the Town of Fairfield and Board of Selectmen. On April 26th, the defendant, Michael Tetro, filed a motion to terminate any stay of execution. On April 27th, the plaintiffs filed a reply to that motion claiming that there was no stay, but if there was a stay, asking the court to lift it. On May 1st, Attorney Baldwin filed an objection to that motion. On May 4th, Judge Bellis granted the motion to terminate any stay of execution which might have been in effect at that time. On May 12th, Attorney Baldwin filed a motion for review of that order terminating the stay. He filed that motion in the appellate court. On May 22nd, the plaintiffs filed a motion to expedite the disposition of that motion, claiming that the election that had been set by Judge Bellis was approaching and they needed a quick review. On May 23rd, the appellate court issued an order granting the defendant's motion for review, granting the motion Attorney Baldwin had filed. They granted that motion for review, but they denied the requested relief. In other words, he requested that that Judge Bellis's order be reversed, and the appellate court denied doing that. So Judge Bellis's order remained in effect. On May 30th, the plaintiffs then filed another expedited motion for an order determining that no stay or terminating any stay in the appellate court. On May 31st, the appellate court ordered that if the defendants wanted reconsideration by the entire appellate court, I think that the original motion was heard by one judge and it was denied, and there was some inquiry made by the defendants as to whether they could have what's called an en banc review, which means a review by all of the judges. And the appellate court ordered that if they wanted that review, that they had to file the request by June 1. On June 1, Attorney Baldwin did file that request, and he again asked the court to reverse Judge Bellis. On June 2nd, the appellate court issued the order granting the en banc review, but again denying the request to reverse the decision, and actually stating that in their view there never was a stay in effect. On June 21, Attorney Baldwin filed what's called an acknowledgement of the transcript order. When you take an appeal to the appellate or the Supreme Court, you are required as the plaintiff to either specify or certify that no transcript is necessary, transcript of the lower court proceedings, or you have to order it. And on June 21st, Attorney Baldwin filed that acknowledgement showing that he had ordered the transcript. That allows the appeal to proceed. On June 21, Attorney Baldwin filed a petition for certification with the Supreme Court in which he presented the following questions. One, did the appellate court properly conclude that no automatic stay arose from the trial court's judgment of mandamus ordering the town of Fairfield to conduct a special election? Two, did the appellate court properly deny the relief sought by the defendants in their motion for review of the trial court's order terminating the stay? On June 29th, First Selectman Tetro sent a letter to Attorney Baldwin reiterating his demand made on April 20th that Attorney Baldwin cease representing the town of Fairfield and Fairfield Board of Selectmen and demanding that he withdraw the petition to the Supreme Court. And on July 3rd, the plaintiffs filed in opposition to the petition. So that's basically where we stand. And like I said, the appeal to the appellate court is pending, and they probably will schedule what's called a pre-argument conference, which means they have the parties sit down with usually a retired judge and discuss whether there's a possibility of resolving it. If not, then they set a briefing schedule, and the appellant would file a brief, then the defendant, or the appellee, and then perhaps a reply, and then you'd argue it, and they'd make a decision. And with regard to the petition for certification to the Supreme Court, and they're just awaiting decision from the Supreme Court on whether to grant it. That's where we are.
Could you explain what that means in terms of certification?
You don't get automatic appeals to the Supreme Court from a lot of things. They're by certification. You have to file a petition requesting that they hear the case, and they have the right to either say, we'll hear it, or we're not going to hear it. That's what that is.
So the application for certification is in essence a decision by the Supreme Court as to whether they will hear that appeal?
It's asking them to decide whether they will hear that particular issue, yes.
Okay.
And I read the two issues that they've asked them to review. So they can say, yeah, we'll review it, or they can say no, or they can say, we'll review it limited to this or that. They have the discretion. It's not automatic.
So at this point, there are two active appeals, if you will, one in appellate court and one at the Supreme Court.
Yes, the appeal to the appellate court is by right. A party has a right to appeal to the appellate court. They don't need certification. So that appeal is currently pending.
Okay. And so it sounds like, what are the next steps from here, I guess?
As far as the petition goes, you have to wait. The plaintiffs apparently filed an opposition saying, don't accept it. And so if they do accept it, then further things are filed by the parties. They may want a transcript, or they want briefs, and then there would be oral argument. It follows the same track as an appeal to the appellate court.
Okay, so that's the Supreme Court.
That's the Supreme Court.
On the appellate courts, what are the next steps there?
They wait for the transcript. The transcript will get filed. The court will probably, like I said, probably schedule a what's called a pre-argument conference, where they get the parties together with a retired judge and say, hey, can you guys resolve this? If they can, they will. If they can't, then it's just scheduled for briefing and oral argument, and they'll decide it.
Okay. Any questions or follow-up questions from the board?
I have a couple, just to clarify a few things. So the appeal that's before the Supreme Court right now pertains to these two items, number 1 and number 2, that were filed on June 21st, right?
Yes, and it's technically not an appeal, it's a petition for certification to
petition.
appeal. Right.
Okay,
So in other words, there's technically no appeal really pending yet.
Right.
Only if the court grants them permission to do
Right,
it.
so there is a petition to the Supreme Court to consider an appeal based on those two things?
Yes.
Okay, so that's that part of it.
And they both relate to the
Appellate court
stay-
decisions.
And the stay. They're only related to the stay. Was there a stay of execution in place? Did the appellate court, properly decide it?
Okay. And the other appeal that remains active within the appellate court, the one that was granted by right, not by petition, that appeal that stands before the appellate court is solely based on the appellate court's decision to declare there is no stay. What is the issue that they are specifically appealing there?
They appealed from Judge Bellis's decision.
Right.
So they are saying that her decision in granting the mandamus and ordering the election was wrong.
Okay, so they're specifically questioning her decision to order the election, not anything else? Or the other?
Yeah, that was filed before the issues of the stay arose, so that is just a straight appeal from a judgment, from Judge Bellis's judgment, yeah.
But it dates back to the original decision on the election, not the subsequent decisions to declare that there is no stay in place?
At this point, that is correct.
Okay. Is there further opportunity at the appellate court to go back and challenge the stay component that I just mentioned, above and beyond the original decision component that is currently there? Does that make sense?
I understand your question, and I don't know whether it's too late for them to challenge that in the appellate court. They may have had to file an appeal, but they have asked the Supreme Court to address it, so.
Okay. And my final question would be, I'm not sure which timeline happens quicker here, and you may not know either, but if the Supreme Court were to conclude to not hear it because it's not something they want to hear, or that they do want to hear it and say they decided against these two motions, would that still leave the appellate stuff alive, or would that finish the situation?
That's a good question. It would still leave the appellate case alive.
It would?
Yeah, they're different issues, and so I would say that it would. I think
Okay.
it would.
Okay, there's just a lot of moving pieces here, and, where I'm trying to get at at the end of my question is, what is the timeline for the end of this?
Well, it's an interesting question. If the Supreme Court granted the petition for cert and said, we will consider whether the appellate court was wrong in saying there was a stay, I think that the defendant's claim is that the election shouldn't have taken place because there was a stay of execution in place, so the judge's order didn't go into effect. The appellate court said, no, that was wrong. There was never a stay of execution, so everything proceeded as correctly. So if the Supreme Court said that the appellate court was wrong, I don't know what the effect would be. I mean, you'd really have to look into that.
Okay.
So there was a stay in place and the election should, I think can get very complicated, quite frankly. And then you still have the issue of the appellate court's review of Judge Bellis's decision. So.
Okay. Good. That helps, thank you. It does. Appreciate that.
Did you have any questions or comments?
Well, a couple things. One, the appellate court, the plaintiffs tried to have that dismissed, and the
Yes.
appellate court denied it and said, yes, we actually want to hear the
The
case.
appellate court, from what I read,
Yeah,
the plaintiff's appeal, you have a certain amount of time to appeal.
Right.
You have 20 days to file an appeal, and there was a question of when that 20-day period commenced. So I think that the basis of the plaintiff's motion to dismiss was that the appeal was not timely filed. That motion was denied, so the court apparently found that it was timely filed.
right.
All right. Given where we are, and since the Judge Bellis ruling, this board really hasn't authorized or voted on any kind of motions or initiative to go forward. What do you recommend we do from here to kind of clarify things
I
in
think
terms of
that
where we stand?
You could vote, if you wanted to have the appeal withdrawn on behalf of the Board of Selectmen and the town. I mean, you're the Board of Selectmen, so you could have that vote. I don't think you could vote, from what I could see, I don't think you could vote as to what to do with the individual defendants. I think.
Oh, yeah,
they're sued in
we're
their
not
capacity.
talking about Mr. Timniak and Mr. Bateson.
Right.
Were sued in their official capacity.
Yes.
And at least everything I've learned says the town owes them that defense, and they're in control of where that goes. So anything we're discussing has nothing to do with Mr. Timniak or Mr. Bateson in terms of that going forward. It's just the town and the Board of Selectmen in terms of what our authorization has been, and based on where we are, what our guidance or direction to you would be going forward.
You could authorize that. If you wanted to, you could say, withdraw the appeal.
I would object to that for a couple things. One, at the time the case was issued, the Board of Selectmen took action, and the Board of Selectmen was the one who was named in the lawsuit. That hasn't changed. the members of the current Board of Selectmen, but when the lawsuit was put in place, the members at the time were there. And then the second thing is that on May 4th, I believe, what I read through the transcript, that Judge Bellis ruled that Attorney Baldwin represented the Board of Selectmen, Ed Bateson, Selectman Bateson, Selectman Timniak. I also believe maybe the town of Fairfield at the time. I don't believe that has changed from the court, although attempts have been made to change that. I believe the judge has ruled that Attorney Baldwin is our legal representation on that.
Actually, that's not what she said, since I was there.
Okay?
What she said was she wasn't going to address that, and she would allow both attorneys to speak for the purpose of that afternoon session. And that was the limit of what she said. She basically said she wasn't going to rule on that, but she would let both attorneys speak. So that's not the case. My concern is that since her original ruling, nothing's come before this board, whatever the makeup was, to authorize any additional expenditure of funds. And, that's definitely a concern, and I take our town attorney's guidance as being significant in that case in terms of, to this board, saying that we've got two actions, one in Supreme Court that, if you look at the timeline, was filed after this board was set up with the current membership. So this board certainly didn't authorize that. And we have an appeal going on to appeal a ruling that wasn't presented to this board to authorize that appeal, give us an indication of the likelihood of winning, or review what the cost might be for that. So I think that as we do with all of our suits, when they come before us, the attorney comes before us and also gives us a likelihood of winning, and also what the potential trade-off would be versus settling versus taking it to court. And we've all been involved in situations like that. This doesn't seem to have followed that process. So
All of the time, that discussion happens in executive session. Okay, that's one. And the second.
And it could have happened in an executive session this time, but it didn't.
So the second thing I'll say is I reviewed the transcript from the May 4th case, and I think she's very clear when she says that Attorney Baldwin is representing the town. I don't see.
And she also said-
I think what she
yeah.
said was that I attempted to file what's called an in lieu of appearance, which means that I'm filing in lieu of, in this case, Attorney Baldwin, so he's out of the case and I'm the lawyer. What the judge said was, I'm not going to deal with that. I'm going to deem that it's in addition to appearance, technically meaning we both represent. So the bottom line, and I don't mean any disrespect to Judge Bellis certainly, but who represents a client is up to the client. It's not up to the court, okay? There are some circumstances where a court might rule on a disqualification motion, but other than that, it's the client that decides who represents the client. So whatever the client says to do, the lawyer has to do, quite frankly.
And I think is my concern over the next steps and where we stand was to clarify that this board has to make a decision about where we go from here. Do we let what it is stand, or do we give direction to the town attorney as to where we want this to go?
Just a question. Since it predates me, can you give me a little history on, from the Board of Selectmen perspective, what has been authorized so far from this table? What has the Board of Selectmen, in its official capacity, what have they authorized, or who have they authorized to work on either our behalf or their behalf or the town's behalf?
The only thing that I'm aware of is a purported meeting of the Board of Selectmen that was not called by Mr. Tetreault. I don't believe that the meeting was properly called, quite frankly, but at that meeting, it was purported to appoint Attorney Baldwin to represent. I believe that the motion was to represent the town of Fairfield. And I think that that's the way the motion was framed now. And that was back in February. So
that predates this timeline.
oh, yeah.
Okay,
It
all right.
predates the judgment by the court. It was really the beginning stages of this case.
Got it.
And So it certainly has nothing to do with an appeal. And typically, if, you know, a client doesn't authorize me to represent them in appeal unless I sit down with them after the judgment comes in one way or the other, and we have a discussion. So I don't know. Probably there was no authority to take an appeal. I mean, that's my opinion.
See, that discussion is something that didn't take place at this board.
Right.
Okay.
And quite frankly,
Sure.
in all candor, when we were in court way back when, and there was a dispute, Mr. Tetro, as the first selectman, authorized an open court, he authorized Attorney Baldwin to represent those 4 defendants in the case that was pending at that point. And that's, in my view, what his authority was limited to represent them in that case. Once the judgment was rendered, now you got to talk about what you're going to do about an appeal. So it's up to him to authorize. He's the one who
Did that,
appoints the attorneys.
does that?
But he did authorize that.
Okay. But all of that predates the original decision.
Oh, yes.
So the question remains, the actions that were taken at that meeting, were they legitimate, number one? And the other question that remains would be whether Attorney Baldwin was properly hired, it sounds like he was, or approved by Mr. Tetro. Was that up to a point, and what point was that up to, and therefore what needed to happen from that point forward to authorize further action? Are those reasonable questions?
Yes.
Okay. Do we need to research to thoroughly answer those questions, or is it something that you can opine on today?
If you want me to do further research, I can do a little research. I mean, I think it all depends on his intent, and the case is a little complicated, the way things have happened.
Yeah, I mean, I wasn't here, so I'm just
Yeah.
trying to make sure that I understand
I mean,
the
I can tell you-
actions and timelines.
It's my practice, certainly, and most lawyers' practices, even in my retainer agreements, appeal is separate, you know.
If I can add, one,
Yeah, please.
we talked earlier about the appeal being the right of the defendants, and that's without question. You've said that here, without question. So, without question, the appeal is moving forward, in my view. And it's a right we have. The board, I disagreed with the decision. I, to this day, believe the town charter is unprotected right now. And I am,
Yeah, we're not, gonna-
Yeah.
Mr. Timniak, we are not going to re-argue the court case. We have a legal decision on that from a judge outside of this. So going back through all that is not what this is about. This is about where we are today and what we have going forward. So I'd ask us to constrain the discussion and comments to that. Certainly, from your individual case, you can authorize that, and I assume have authorized that. I'm assuming Mr. Bateson has done the same. My point is that this board, while we have the right to appeal, has not authorized the expenditure of money on the town's behalf to do that appeal, and I think that's what I was looking for in terms of what stepped through on this. And in terms of where we are, especially the most recent motion to the Supreme Court that was not addressed by the members of this board who are sitting here today. And that was filed after this board was seated. So there's no question that that did not come before this board. And if that type of legal strategy should have taken place in public session or private session, that was okay. No session was scheduled or on the agenda or had taken place. So from that standpoint, I guess I would look for a motion from the town attorney, frankly, or direction, a motion to direct the town attorney to withdraw the Board of Selectmen in the town of Fairfield from both the appeal and the Supreme Court appeal, since those were not properly authorized this board since the original appeal. And if that's, so I guess the first thing we do is need a motion to put that before us. So may I have I'll make that motion to put that before us, or on our agenda, if you will. Is there a second?
Second.
All right, any further discussion on putting that on the agenda before us?
well, a couple things. One, I thought you just mentioned you wanted more time to do some research and do some legwork on this.
Well,
Is that-
he asked me
This
kind
is
of about
about putting
another
it,
issue.
time out,
Yeah.
gentlemen, This is about putting on the agenda. We'll have a chance to come back to that when we have the vote on the motion, if you will.
I will vote against it going on the agenda.
All right? Then with that, all in favor? Say aye.
Aye.
All opposed?
No.
All right, the item is before us. Now, if you'd like to make that point.
All right. A couple minutes back, you mentioned that you wanted more time to do some research and to look into certain things. You just asked for that. Do you still request more time?
On what the first selectman just was talking about, no. I mean, it's clear that they have the right to direct me to withdraw the appeal, to file an appearance and withdraw the appeal. But as you know, that's not going to end the appeal. It just gets the town and the Board of Selectmen out of it.
Right.
You can't, as far as I see it, and I haven't really looked into it in great detail, in all honesty, what the obligations of the Board of Selectmen are vis-à-vis any officers of the town. I'm not going to get into it now. So what I'm saying is that as far as I know, just them withdrawing on behalf of the town and Board of Selectmen, the appeal continues.
May we hear from the attorney who is
No.
currently representing the town and the Board of Selectmen?
He doesn't currently represent the town and the Board of Selectmen. He's been fired twice.
From the May 4th Judge Bellis ruling,
She did not rule that.
she said that he was representing the town on May 4th.
That was not her ruling.
That's what the transcript says.
I was there, and
Well, I think if
Attorney
you read
Lesser
it,
clarified.
I think if you read it, if you have the transcript there, I'll take a look at it, but my recollection is that she said, for the purposes of this case, I'm letting them file in addition to appearance, and I'll let the appellate court deal with the issue when they get to it. So I don't think it's been raised. First of all, I don't think there's any court, under these circumstances, is going to say that a client can't direct how the litigation is going to go. Okay? And if my client is the town, and technically the Board of Selectmen, they can vote to have me do whatever they want to do. As I've said, it's not going to stop the appeal, but they have the right to do it. And regardless of what a judge says, that's my opinion.
well, when you say that, it's not going to stop the appeal for the two selectmen. It will
Correct.
stop the appeal on behalf of the town of Fairfield and the Board of Selectmen.
Yes, it
Thank
will.
you. Any further discussion?
Well, and again, I would like to go back to when this all started and the representation, the people who have been, it's unfortunate that the Board of Selectmen was named in a lawsuit, but at the time, the Board of Selectmen chose this course of action. So here we are in the midst of an appeal and following the legal right of the board at that time, and we're essentially taking that right to have the board included from that moment. To me, it's rolling back the clock.
But
No, it's not. The Board of Selectmen never made a decision to proceed with the appeal. Never. The Board of Selectmen did not have the facts of the case reviewed after the judge's decision. It was never on agenda. It was never reviewed by this board or authorized to go forward or authorized to spend any money on this going forward.
just one point on that, though. Whether or not, and I believe that you're correct, but whether or not you are, a client can always, at any time, say withdraw the appeal. What happened in the past is really irrelevant to what's happening today. They can decide at some point, hey, we're done, withdraw the appeal, which is what they appear to be doing, and it's their right to do it.
So your position is that the prior board's decisions no longer hold water on this?
Correct. On this issue, they
They're
can
not-
at any time withdraw the appeal.
And there
They can
was
say
no
we're finished.
decision on the appeal.
I'll
This
be-
board never voted on that, never was informed of the cases, the likelihood, or what the appeal would be based on, and why the judge's decision might not be correct.
Okay, I'll be voting against this.
Okay? And the Supreme Court filing was done after this board was seated, so we never voted on that. All right? So nobody had authorization to initiate actions that would cost this town money without the authority of this board, and that was not given by this board, and this board was the board that was seated at that time. Any further discussion?
Yeah, I just want to clarify a couple things, please. Can you go back to Mr. Tetro's comments about this particular motion? Can we review the motion,
Which,
the one that's on the table?
yeah, I think he needs to restate it. I think the motion, as I understand it, is just that I'm to file an appearance and withdraw the appeal on behalf of the town and the Board of Selectmen.
Yeah. Sheila, is that what you had?
to direct the town attorney to withdraw the appeal on behalf of the Board of Selectmen in the town.
That's it.
Right?
And that would be,
With both the appellate court and the Supreme Court.
is that as of a date certain, or?
That's as of immediately.
So you're talking about today going forward? Is that what
Well,
that-
once you withdraw it, it's withdrawn.
Right,
So there isn't a comeback in that.
okay. Okay.
So it's just removing the Board of Selectmen.
And the
Correct.
town.
This has nothing to
And
do
the town.
with your personal case or Mr. Bateson's case. Both of those can proceed. The town has an obligation to defend both of you in a lawsuit, and the town is not backing away from that obligation in any manner, way, shape, or form. You were sued in your official capacity as a selectman, and the town is going to defend you in that capacity. And your decision to proceed with the appeal is your decision and is not impacted by the actions that this board has taken. Is that
I got you.
clear enough on,
I hear what you're saying.
okay.
I'm still going to vote against it.
That's your option. That's your option.
For the-
I'm still not clear on one thing. As far as the old board versus the current board, and can you just kind of help me understand the role of the old board versus the role of, are we undoing something that the old board did? I just want to make sure that I'm
No.
crystal clear on what we're
No,
voting.
you're not undoing anything. It's like any other case. The town gets sued. We defend the case.
Right.
At some point, we decide, hey, maybe we want to settle the case. We meet with our lawyer, the Board of Selectmen, you folks do it all the time. You agree to pay something, the case is settled, it's stopped. Conversely, if we sue somebody, at any point, we can decide to stop it. I mean, so the fact that it was started at one point in the past, I don't think has any effect on what your rights are now. You can always withdraw the case.
And in my mind, there's a major issue of the fact that once the judge ruled, nothing came back to this board for further consideration or explanation of why it should go forward.
It's not going to stop the appeal, though. You need to understand that.
It's not going to
The
stop.
appeal by the selectmen.
Correct.
Okay, that's separate. We're not talking about that.
I
That's not
understand
what
that,
this-
right.
Yeah.
Right. Okay.
All right.
Yeah, I think so.
All right. Any comments from the public? You'll come to the podium. And I would just ask if you can confine your comments to the motion before us. We're not here to re-litigate the case.
Thank you, Mr. Tetro. James Baldwin, 150 Inwood Road, the attorney who, up until this point in time, has been representing the town of Fairfield and two of the three members of the Board of Selectmen, excluding yourself, and the Board of Selectmen. Let me point to something which is really obvious here. This is an adversarial relationship between the first selectman, the town attorney, and two prior members of the Board of Selectmen. Without a doubt, that is a unique situation, and one which heretofore has never existed before. So citing past precedent for actions by this board, including the motion that's come before it, has no relevance. What is relevant is the adversarial relationship still exists, that you have always had separate counsel due to that adversarial relationship. What also matters greatly is Judge Bellis's order, that she is disallowing the first selectman's attempt on numerous occasions, including the day of the May 4th hearing, for me to be, for the town attorney to appear in lieu of myself on behalf of the town, the Board of Selectmen, and the two selectmen. She specifically, expressly said no. She specifically, expressly said that you ought to take it up with the appellate court. And there are vehicles, legal vehicles, in order to make that happen. And I'm going to stop my comments there, because I think this board has already crossed the line in terms of discussing strategy and in terms of discussing the town's legal issues, which are in litigation. And so I'm going to leave it at that. I'm going to caution the board accordingly that it does not belong here. Rather, it belongs in the courts, where Judge Bellis herself decreed it belongs. And I think that it's dangerous for this board to ignore that court order.
Thank you. Any other comments from the public? Seeing none, it's back to the board. Would you like to caucus?
I would.
All right, we'll have a 10-minute caucus, is that enough?
That would be fine.
All right, we are back in session. And thank you for being patient with us while we took a break. Based on the sensitivity of the issue, there are some questions on the wording of the resolution before us. And I think that we would like some more time to think through that. So with your permission, I'd ask Mr. Kiley to withdraw the motion.
So moved.
And I would withdraw the second, so that item is not before us at this point. And we would, given there's no resolution before us, we would move on to the next item on the agenda.
Would I be allowed to add something to the minutes, the court's transcripts? We did discuss it, so I'd like to add them as backup.
Yeah, if you would submit that to my office,
Okay.
I'll have that reviewed by the town attorney, and we'll definitely add it. I just want to make sure we're adding a complete copy.
Okay. All right.
Next.
That was the May 4th, rule order Judge Bellis gave, and the February 23rd, where I think that was the initial one, where it said who was representing who.
Correct. There's no dispute on the February 23rd one,
Right.
because that was authorized by me. There is on the May 4th, so
Okay.
yes.
Great.
Then, next up, the tax collector. To consider and act upon tax refunds as recommended by the tax collector in the amount of $60,781.05. May I have a motion to accept?
I'll make a motion.
A second?
Second.
All in favor?
Aye.
All right. Next up, to hear, consider, and act upon any other business that shall properly come before this meeting. There's none that I know of. And with that, may I have a motion to adjourn?
I'll make a motion.
A second?
Second.
All in favor?
Aye.
Aye. Thank you.